Hello, Mariano. It is a pleasure speaking to you today. So I'm having here in our Privacy Espresso Mariano Peruzzotti. He's a lawyer in Argentina from OJAMBF. And you probably noticed that Alessandro is not here with you guys today. He's on vacations, enjoying his well-deserved rest. And I'll be here for the very first time interviewing some member from our Privacy Rules Alliance. So please be kind and patient because this is my very first time. So Mariana, hi. It is really, really great to be here with you today.
Hi, Luisa. Hi, everyone. It's nice to be here as well. Thank you for the invitation.
Good. So in our Privacy Espresso, what we usually do is we have an expert from a country telling us a little bit of information from their country related to a privacy issue. And this time is very special to me because a client of mine really wanted to ask our Argentinian member about a subject that we believe is really a concern for many companies. So today, our subject will be the obligation to register databases in Argentina. So, Mariano, I'll start with the first question now, with a basic one. So, what is this database registration requirement provided for under the Argentinian Data Protection Law? And does it necessarily involve data localization?
Okay, thank you very much for this first question, Luisa. Let me start with a brief introduction of the Argentine regulation, the data protection legal framework. Argentina has a very old data protection law that was enacted in year 2000. Almost 25 years have passed since enactment, and the text of the law remains as approved by that time. And this regulation, the Argentine personal protection law, was inspired on the EU regulations approved by that time, by the 90s, particularly the Spanish Law Tab. And those EU regulations included a registration of databases. It was basically a notification of the data processing activities. This obligation was introduced in the Argentine Data Protection Law. This was the source, or at least the reason why the legislators in Argentina considered the need of implementing or putting this obligation in the Argentine Data Protection Law. So basically, this obligation implies that Argentine companies will have to report the data processing activities with the Argentine Data Protection Authority by means of this registration of databases proceeding, as we call here in Argentina. This basically is a duty for data controllers to collect and process personal data lawfully. The registration involves completing and submitting a free and online registration form. Generally, the Argentine Data Protection Authority will require companies to report data processing activity involving the following cases or data subjects. For instance, human resources, which means the personal data of employees and candidates, vendors or suppliers, clients, the CCTV, video surveillance, marketing, and other cases, for instance, sweepstakes and contests. So basically, these are the main cases in which a company will have to report its data processing activities. This basically is for Argentine companies and probably will imply that an Argentine entity that will collect and process personal data will be in this duty of complying and submitting the form legally to be in compliance with the law.
Good, great, super clear. Thank you, Mariano. And foreign companies, they are not subject to this requirement, or there are cases which they are actually obliged to comply with that requirement?
Well, that's a good question as well, because since November 2022, foreign companies are mandated to comply with this obligation as well. So if a foreign company is collecting and processing personal data of Argentine data subjects, they must comply with this obligation. And this is curious because before this new regulation, there was no possibility for foreign companies to comply with the data protection registration proceeding, because this was conducted through a platform that only is available for Argentine companies, or at least those companies that are registered with a specific code that is granted to local individuals, national Argentine individuals, or companies based here in Argentina. So foreign companies were not able to comply with this obligation. In November 2022, the Argentine Data Protection Authority created a kind of specific form for foreign companies, so they should comply with this obligation. To that end, they must submit certain information. I mean complete a form, online form, providing, for instance, the name of the person who is authorized to request the registration, the power of attorney or the authorization letter, the name of the controller, the supporting documentation of the controller, such as, for instance, the bylaws or the articles of incorporation, and the contact details of the data controller. Then the Argentine Data Protection Authority will provide a link that will allow the access to a second form in which the controller will have to provide specific information about the data processing activities. It is important to know that there is no registration fees for this proceeding. I mean, there is no cost involved, at least for any fee for registration, and that the registration of databases does not imply the disclosure of confidential information. The companies only have to respond a form, provide the answer in the sense of how they are processing the information, but they should not share databases or information, personal information. This is very important because generally companies are very concerned about the fact that they probably will have to provide a copy of the databases, which is not necessary according to this obligation. And finally, once the database registration proceeding is complete, the Argentine Data Protection Authority will issue a certificate of registration. And there is no, as mentioned, there is no obligation to register at this every year. There is no annual renewal required for this proceeding.
Okay, got it. And in practice, Mariano, is the local data protection authority really monitoring this? And what happens if the authority finds out that the data controller did not follow the requirement?
Well, since the enactment of the Argentine Data Protection Law, the Argentine Data Protection Authority has not been extremely, I would say, active on the enforcement of the law, based mainly on budget and workforce restraints. However, there has been an increase in enforcement action conducted by the Argentine Data Protection Authority over the past recent years. The Argentine Data Protection Authority has imposed some sanctions to both basically to private entity for non-compliance with the with the Argentine Data Protection Law, particularly for not registering databases. This is mainly the reason why the Argentine authorities may start investigating a case when they realize that a company has not registered its databases. So this may trigger the need of conducting an investigation according to the Argentine authorities, and just start analyzing all the different obligations under the Argentine regulations. And well, non-compliance with the Argentine data protection law can result in fines from Argentine pesos 1,000 to 100,000, which will be approximately on fines ranging from $1 to 100. I mean, the amount is not significant because the Argentine law is outdated. But well, besides the sanctions, it must be considered the reputational risk here, and also that there is some initiative, some bills trying to amend the law and imposing more sanctions that will be more high in the amount. And basically, these are considered by the Argentine Congress right now. Well, that's all. As I mentioned, the lack of registration may trigger an investigation of a company conducting business in Argentina. So it is important for local companies and foreign entities doing business in Argentina to just take a look on this obligation.
Got it. This was very helpful, really clear. And well, I think that's all the time that we had for today. Mariana, I want to thank you again for being here with me today. I think it was really great. Thank you.
Thank you. It was a pleasure.